Okay, I think we're ready to start. Well, good morning to everyone who's logged in, and thank you so much for joining us. I'm Michael Good, and with me are two experienced practitioners, Victor Sahn, who, like me, practices bankruptcy law, and Jeff Pomerance, a corporate and transactional attorney with a focus on mergers and acquisitions. Together we wanted to cover a relatively narrow issue that crosses both of our respective specialties, and it's this. How can it happen that an ostensible lending transaction may be recharacterized later on as an equity investment? There are a number of insolvency-related scenarios in which after-the-fact characterization can take place. And one of the more common ones involves an investor, often, but not necessarily always, an insider who's making a subsequent loan in order to protect an earlier cash infusion. The cases involve small business debtors, larger corporations, and even Ponzi scheme operators, all of whom we'll be looking at very briefly today. But since this is really judge-made law, we thought that one of the best ways to get into this issue would be to walk through a few of those cases. But first, before we do that, I'd like to offer a very short disclaimer, and it's that our focus this morning will be primarily on circuit-level decisions. So even though a number of recharacterization decisions have been issued by lower courts, and we're aware that at least some of our entities may have participated in litigating those decisions, our treatment won't necessarily be exhaustive. What we'd like to try to do is give you an overview of the area. And so on to our cases. We'll take them in chronological order so that you can see how the law has developed through the decisions. First, one of the earliest recharacterizations, at least in the bankruptcy context, goes back to the mid-1980s. This case, a case entitled N&D Properties, involved a small retail furniture business started by a Georgia CPA with funding from one of his clients, a housewife who had come into an inheritance of several $100,000. After several rounds of direct loans to the furniture business, that very modest inheritance soon became a much smaller inheritance, and to make matters worse, the housewife had taken an equity position in the business and had further collateralized third-party loans with a pledge of stock she owned, and which was unrelated to the furniture business. As the business continued to deteriorate and the third-party lender called its loan, the insider housewife paid the lender, took assignment of the lender's first priority security interest against the debtor's assets, then lent the debtor the $1,200 necessary to file a bankruptcy petition, and finally filed a first priority secured claim of $320,000 in the debtor's case. The trustee in this case sought to subordinate and invalidate the insider housewife's claims. Of the original $320,000 in claims, the bankruptcy court ultimately allowed approximately $133,000 in verifiable loans, deemed $60,000 of that to be capital contributions, and equitably subordinated the balance to general unsecured creditors. Now, before we go further, I'd like to take a moment to pause and point out that equitable subordination, which if you practice bankruptcy you may have heard of, is a related concept that we'll touch on later in the presentation, but it's distinct from recharacterization. In any event, in the N&D Properties case, the district court reversed the bankruptcy court as to both recharacterization and equitable subordination, and upheld the insider housewife's allowed claims. The 11th Circuit split the difference between the Bankruptcy Court and the District Court, refusing to permit recharacterization but allowing equitable subordination. There are two primary takeaways from the N&D Properties decision. The first is the fact-based approach employed by the 11th Circuit to determine whether recharacterization is appropriate. And as we'll see, bankruptcy courts have applied, and even circuit courts rather, have applied a number of factor-based tests to the evidence before them in order to make that determination. And second, the test for recharacterization employed by the 11th Circuit in this early case has since been characterized as one of the broadest ones imaginable. No other circuit decision appears to have followed this test. Second, the auto-style decision out of the 6th Circuit involved an indirect funding mechanism used by corporate shareholders to advance money to a struggling debtor. To summarize some relatively complex facts in this case, the shareholders funded advances to the debtor through a credit facility that had been previously extended to the debtor by a third-party senior lender. The shareholders then entered into what were termed participation agreements with that lender. When the debtor filed for bankruptcy protection, a junior secured creditor contested that part of the senior lender's secured claim, which was ultimately attributable to the shareholders' contributions, and claimed that those contributions were in fact equity, and therefore junior to the junior creditor's liens, or that they should be equitably subordinated. The bankruptcy court refused to recharacterize or equitably subordinate the shareholders' loans, and the district court affirmed, as did the 3rd Circuit. For our purposes today, and in addressing the recharacterization portion of that appeal, it's important to note here that the 3rd Circuit employed, or I'm sorry to say that the 6th Circuit employed an 11 factor test derived from an old tax decision known as Roth-Steele, and found that those factors, on balance, supported the bankruptcy and district court's decisions not to recharacterize. Third, Hedged Investment Associates was a case involving a Ponzi scheme in which some investor victims sought to recharacterize or subordinate loans made by a third party to the debtor. The bankruptcy court refused to recharacterize the loans, but equitably subordinated them. The district court reversed the subordination claim, and the 10th Circuit upheld this ruling. The 10th Circuit employed a 13-factor test and performed what essentially appears to be a balancing of those factors, finding 6 factors that indicated a loan and 3 that did not. Discussion in this case also traces out the evolution of case law standards within the circuit for characterization. The court moved away from an earlier, simpler 3-pronged test to a more extensive set of criteria employed by tax courts. Fourth, Submicron Systems, which is the 3rd Circuit case, involved a supplier to the semiconductor industry which attempted to finance its way out of several very difficult years in the late 1990s. The company had a working capital facility and senior subordinated notes, but issued a series of secured junior notes between 1997 and 1999. Eventually, the company was acquired through a Section 363 sale in bankruptcy court for consideration which involved some cash and assumed debt, but primarily the consideration was credit bids using claims which had been assigned to the purchasing entity by the junior lenders. The junior lenders, in turn, received equity in the acquiring entity. The Unsecured Creditors Committee in this case attacked the transaction by, among other things, seeking recharacterization of the senior debt or equitable subordination. The district court, which heard the case, declined to recharacterize or to equitably subordinate, and it employed a 7-factor test used previously in a Delaware bankruptcy court decision known as color tile, and the Third Circuit affirmed. The Third Circuit found the language of the documents to be important, as well as the way the documents were portrayed to the outside world via SEC filings and financing statements. The borrower's lack of capitalization and the junior noteholder's participation on the borrower's board were not by themselves dispositive, but rather, in this case, the Third Circuit balanced the lack of capitalization with the lender's need to protect their prior investment. Now, while we're discussing this case, it's worth noting that Submicron Systems was relatively recently followed by the Delaware Bankruptcy Court in a decision involving Scott Cable Communications, and I've included the site down here at the bottom of the slide and would commend it to you. It's very interesting reading. The facts of that case, which cover nearly 50 pages of an 88-page decision, involve the IRS's efforts in a 1998 Chapter 11 case to unwind secured debt issued under Scott Cable's original 1996 plan of reorganization. Our time this morning, as well as our focus on circuit-level decisions, really doesn't permit us to give the case the sort of in-depth treatment in this morning's presentation that it might otherwise warrant. It's a very interesting case, but one noteworthy aspect of Scott Cable, which, as I mentioned, is a very interesting decision in several respects, is that the court denied recharacterization by reaching for its multi-factor analysis all the way back to the original 1988 financing transactions, which gave rise to the claims for which new debt was issued under the plan. It placed, and I'm quoting from the decision here, it placed particular emphasis on the party's intent at the initial funding. Now, Scott Cable was a case where the debt issued under the 1996 plan of reorganization didn't represent any new money following the creditor's initial loan. But the analysis in Scott Cable raises the issue of whether an initial round of equity funding will taint any subsequent debt advanced by the same party. A subsequent Delaware District Court recharacterization decision issued this March, entitled Optim Energy LLC, also takes the same initial funding approach to its analysis. Again, however, rejecting an effort to recharacterize the debt as equity.
Michael?
Yes.
This is Victor.
Yeah.
I think the Scott Cable case is also really worth looking at because, at least from the cases you've talked about and up until now, we have had circuit court opinions that have taken an analysis and said these are the factors you apply, and the decision below is upheld or the decision below is reversed and remanded for further findings without getting into facts, because circuit courts typically don't do that. At least certainly not in anything approaching the detail. That's not their function. And in the Scott Cable case, you have a very, very smart judge in a case with a great deal of money at stake and with very, very able counsel on both sides representing the parties. So when you talk to your client, or your client is a lender or a debtor, either one, and they say to you, hey, what's going to happen? You know, don't tell me about the factors, or don't tell me what courts have held. Tell me how courts have actually analyzed this. I think this case, whether it's correct or incorrect in its holding, certainly gives a trial court analysis in tremendous detail that can be a roadmap in terms of talking to your clients about what might happen if you actually decide to, as a trustee's counsel or a debtor in possessions counsel, to bring on such an action, or as a lender looking at it and facing such an action being brought against you with regard to one or more of your pre-petition loans.
It's a great point, and to your point, I think it highlights the way that bankruptcy courts and even district courts are inclined to take the sort of multi-factor tests that we're talking about here and actually apply them in the real world. So it's a really excellent point. Let me move on here, if I can, to the fifth case that we'd like to cover very briefly. Dornier or Dornier, I'm not sure exactly how you pronounce it, but this aviation case out of the circuit involved a debt arising from the sale of spare parts by a corporate parent, in this case Fairchild Dornier, to one of its subsidiaries. Dornier was, as I said, the North American subsidiary of a German aircraft manufacturer. The parts were sold so that Dornier could provide warranty and opening support to Fairchild's customers, with some parts sold for a profit to non-warranty end users. After some former employees filed an involuntary petition against Dornier, the case was converted to a Chapter 11 reorganization, but it wound up in a liquidation. Fairchild, the parent, filed a $146 million claim in which the Unsecured Creditors Committee attacked as deserving of either recharacterization as equity or equitable subordination. The bankruptcy court disallowed $10 million of Fairchild's claim and recharacterized all but approximately $6.5 million of the balance. The district court reviewed the same factors as the Sixth Circuit had in Auto Style and the 10th Circuit in Hedged Investment Associates, and focused in particular on the 6 factors that appear on this slide. Both the district court and the Fourth Circuit Court of Appeals affirmed the bankruptcy court. Well, that was the state of the law in 2006. Of those circuits recognizing a bankruptcy court's ability to recharacterize debt as equity, a majority of circuits had explicitly relied on the court's inherent equitable powers under Section 105 of the Bankruptcy Code. Additionally, there was an evolution toward applying the same factors as those employed in tax cases where the debt-equity distinction was at issue. But in the end, and as the Third Circuit put it, the fundamental inquiry was and is into what the parties intended. And you can see that analysis come through in the Scott Cable Communications case. This is an analysis, again, similar to the one undertaken in the tax context. Well, that was 2006. In 2011, the Fifth Circuit joined its sister circuits in a case called Lothian Oil. And this case involved 2 loans made to the debtor in 2005 by a non-insider individual, which were to be repaid from royalties and equity placement proceeds. In 2007, the debtor filed a Chapter 11 case and confirmed a plan for liquidation 1 year later. The same individual received payment in full for most of his claims, but the bankruptcy court rejected the claims based on the 2 loans just mentioned on the grounds that they were common equity interests. The district court reversed the bankruptcy court on the grounds that recharacterization could not be extended to claims asserted by a non-insider creditor. And the Fifth Circuit finally reversed the district court, holding that there is no per se rule protecting non-insiders' claims from recharacterization. But what distinguishes the Fifth Circuit's ruling from that of prior circuits, all the ones we've just looked at, is that it was based on the claims allowance process, and in particular on a Supreme Court precedent which stands for the proposition that the rights of parties, therefore claims, are determined with reference to non-bankruptcy law. This is one of those decisions, the Lothian case is one of those decisions where the reasoning is as important as the result. Because though several circuits recognized the ability of bankruptcy courts to recharacterize debt, not every circuit had. the Ninth Circuit, the Bankruptcy Appellate Panel had previously held in a 1980s era decision titled In Re Pacific Express that bankruptcy courts did not have the power to recharacterize claims, but were limited only to equitable subordination. Pacific Express was roundly criticized by many courts across the country. In fact, even here in the Central District, in an appeal of recharacterization claims in Daewoo Motors Chapter 11 case, the district court simply refused to follow Pacific Express on the grounds that district courts aren't bound by the Bankruptcy Appellate Panel. However, following Lothian Oil, the analytical landscape surrounding recharacterization changed. In 2013, the Ninth Circuit heard an appeal in a case known as Fitness Holdings. Fitness Holdings was a home fitness company whose operations had been funded, in part, by a first priority secured credit facility and term loan provided by a third-party lender, and by a series of unsecured subordinated notes held by the debtor's sole shareholder, an entity known as Hancock Park. The shareholder was also the guarantor for the first priority loan. After a series of amendments to the secured loan, the lender, Pacific Western, agreed to refinance both the secured debt and the junior unsubordinated notes with a new first priority term loan and a line of credit. Just 13 months after the refinance, Fitness Holdings filed a Chapter 11 case, and the committee filed a fraudulent transfer complaint to recover the proceeds of the refinance from Hancock Park. The basis of the fraudulent transfer claim was the committee's position, for which the committee requested declaratory relief, that the original subordinated notes held by Hancock Park were in fact equity investments, so that their subsequent repayment was for less than equivalent value, and therefore constructively fraudulent. The bankruptcy court dismissed all claims against Hancock Park with prejudice. Now, Fitness Holdings' case was converted to a Chapter 7, and a trustee replaced the committee. The trustee appealed the bankruptcy court's prior ruling to the district court, which affirmed, citing Pacific Express. But the Ninth Circuit vacated the dismissal and remanded for further proceedings in the bankruptcy court on the issue of whether state law afforded a right to repayment of its notes. I'd like to take a minute and unpack the Ninth Circuit's reasoning during the next couple of slides. First, the Ninth Circuit recharacterized the term recharacterization, discussing it in terms already defined by the code. Next, the Court of Appeals very carefully laddered its way through a number of defined terms to conclude that recharacterization of a debt was permissible if the debt in question did not constitute a right to payment under state law. This is the same approach used by the Fifth Circuit in Lothian Oil, which avoided reliance on the bankruptcy court's inherent equitable powers and instead rooted its analysis in the text of the bankruptcy code itself. Well, if state law determines the ability to recharacterize a claimed debt as equity, then the natural question is, what does state law say? Delaware appears to look to the terms of the contract and applies a multi-factor test in the event of ambiguity, but not every state addresses this issue. In California, for example, there appears to be no clear guidance arising from state law. And so, unless the debt documentation itself incorporates the law of a state which speaks directly to the recharacterization issue, state courts may be likely to turn to federal tax law. This is apparently what Texas law does, and the Lothian Oil decision, which itself is relied on by Fitness Holdings, cites several federal tax decisions providing a variety of factors under which a cash infusion may be characterized as debt or equity. This slide breaks out all the factors described by those decisions cited by Lothian Oil. And for our presentation today, what we thought it would be useful to group those factors by relationships between the parties, facts surrounding the transaction, documentation, and the subsequent performance of the parties. One of the interesting features of comparing the various multi-factor tests referenced by Lothian Oil is that it's possible to see a relatively high degree of overlap. And that is to say, of 20 separate factors identified in 4 decisions, 9 are common to all 4. And I wanted to pause here and perhaps toss out questions for consideration. And if any of our listeners have any additional questions or comments, please don't hesitate to send them in. So, Jeff, question for you. We've been discussing cases involving a number of different types of financing structures and instruments. Everything from a highly sophisticated third-party deal structure in the auto-style case to what appears to have been a simple one-page note in Lothian Oil. One sort of arrangement that didn't seem to have come up, at least in the circuit courts, is an obligation based on a hybrid instrument with both debt and equity features. I know these types of instruments are relatively commonplace, and so I wanted to ask, as a practitioner doing significant work in this area, in your experience, what types of hybrid instruments would you say are most common?
That's an excellent question. And as you see from some of the cases that we've just looked at, they really come in all flavors and stripes. You have investments through participation agreements, as in Lothian. You have credit facilities, I'm sorry, you have the bankruptcy loan provisions, or the pre-bankruptcy loans in Lothian. You have the participation agreements. My experience has been that typically it's addressed in 2 facets. Number one, we saw what derivatives, the problems we had with derivatives in recent times, and most of the clients that I counsel and deal with, in terms of hybrid, focus on a convertible debt kind of play. Again, the features vary from stated interest to interest plus PIK interest, which is interest that is then applied to the principal, and then there's interest on the interest, if you will. Again, the PIK notes seem to be more common than late. Convertible notes with all kinds of provisions that seem to sometimes go beyond the traditional loan term maturity date interest payment. And it's also broken down, Michael, not in terms of just the hybrid instruments, but the hybrid investment. And by that I mean that sometimes one particular investor will both contribute what they believe and what we structure as debt, a debt play, and they'll also have an equity position, be it in the form of a preferred stock, be it in the form of a warrant. So it really varies. Actually, that's what makes transactional work so interesting, is that each situation creates its own opportunity.
That's a great answer, and let me just follow it up with another question here. In your experience, you just mentioned debt features versus equity features. Does one characteristic, either debt or equity, tend to predominate in the many of the instruments that you see, or is it really just completely dependent on the facts of the case?
Well, again, it's on one level it's fact specific. There are a number of the 11 tests in auto style, of course a few more that jump out from the outboard marine case that added, ratio of the shareholder loans to capital, submicron at 7-factor. But, it's interesting, getting back to the State Street Bank case, there was very powerful kind of an overriding thought that in dicta that the judge conveyed that I think bears some, concern in terms of which factors or what things, and the judge in that case stated that there's an overarching inquiry, whether the parties called an instrument one thing when in fact they intended it as something else. The intent may be inferred from what the people say in their contracts, from what they do through their actions, and from the economic reality of the surrounding circumstances. And so, it's interesting, as a transactional attorney, if I can digress but a moment, one of the things, when we put together documents, when we see deals, when we see opportunities, there's kind of a multi-front approach. My first job is to help evaluate, and certainly to structure, but also to memorialize the agreement of the parties. The second part is to create a document that then is acceptable to the parties. And you can draft a lot of documents that people look at and say that sounded great in theory, but now that I see it, I don't want to sign it. So you have those types of issues. Then you add to that, as a transactional attorney, you want to build into your agreement the types of terms and provisions and protections that give our colleagues that go into courtroom arrows in their quill so that they can defend and successfully defend challenges to the documents that we've drafted. So from that standpoint, kind of stepping away for a moment about the specific tests, and I thought, Michael, you did an excellent job of bringing out kind of the complexity within this narrow area. Before Fitness Holdings and before Lothian, as transactional attorneys, we were comfortable, if you will, dealing with the tests espoused in the Roth tax analysis, primarily because we wanted our transactional documents that say debt to withstand the challenge of the IRS as debt versus equity. So it is already kind of in our lexicon of issues to approach, our checklists to address. And so from that standpoint, the case law that has espoused the 11-factor test was already kind of on our radar. And so what created new opportunities is, as the case law develops, I mean, as an example, and you touched on this, in Lothian, one of the specific aspects is you had two pre-bankruptcy loans which stated the debtor would repay the loan in the form of equity interest and royalties, and did not specify interest rates or maturity dates. So Lothian applied Texas law and Texas state law and ruled that under Texas law, the interest created by the lender's agreements with the debtor constituted common equity interest at best and not debt. So what it requires us to do as part of working through the deal and making sure the deal gets done is being sensitive to what factors we need to think about. And certainly we think about the 11 factors that are espoused in the Third Circuit or the Sixth Circuit through Roth, because we want our debt documents to be debt documents. One of the things, Michael, that isn't really touched on, and perhaps is the subject for another webinar, is the tremendous downside if this goes wrong. If you think you have a debt document, and for tax purposes and reporting purposes, and even for all kinds of other perhaps ratios within financial documents, and you find out that your debt is really equity, it can bear significant repercussions to all of the parties involved. And what we're seeing, and what I'm starting to see, is that this area and this concern, which may be born originally out of tax and bankruptcy issues, is now starting to see its way into securitization transactions, letters of credit, and the provision of payments of guarantees. So in a roundabout way, to kind of get back to your initial question, what factors, we try and look at all of them. Me in particular, the ones that I'm most sensitive to tend to be, I look at who's doing the investing, the capitalization, the terms of the documents. Is there a maturity date? Is there interest? Is there interest payment? You know, most insiders want to be nice in terms of trying to help their company grow.
Right.
So they do some nice things. For instance, sometimes they'll defer interest, they'll defer and extend credit maturity dates. And believe me, when you represent the borrower, these are wonderful. The problem is that as these things continue to evolve, you start stepping away from what might really look like debt to what might be considered equity in light of all the case laws. So there are so many factors we look at. It really is case by case. I know one thing, and that is that, and perhaps we can touch on this a little bit later, but getting back to the State Street Bank, there were three things that kind of planning recommendations that I think now's a good time to at least throw them out for discussion at a later point. And
Sure.
that is three things that we, as transactional attorneys, we've got to think about. Number one, you got to write documents that generally resemble debt agreements. When you start getting too cute and too sophisticated, sometimes your creativity and earnest in helping your client actually becomes a real problem. So again, you've got to write documents that generally resemble the debt agreements. We can talk about that. I could suggest later some ways to approach that. Number two, act as a debtor might ordinarily act. Think about how debtors act. And for those, especially in the case of insiders who are torn, you've got to take off your investor hat, your equity hat, and you got to put on a debtor hat and say what a debtor might do. And that ties to the third thing that State Street Bank, the judge, I thought, kind of brilliantly brought out, and that is before any investment, give thought to the economic reality of the situation. In other words, would a prudent lender have extended credit to the debtor under similar circumstances? So these are the kinds of factors and thoughts that I look at when we sit down to counsel clients on, again, a case-by-case basis. And lastly, you know, one of the things that I like to think that everything I do is of the utmost importance, but I have to admit that in many instances that transactions tend to be the tail wagging the dog. The key is the deal has to get done. The key is the deal has to make sense for the parties because they need to sign it. And too often, in our earnest to try and help our clients, we create opportunities that then provide challenges as we're seeing through this case law.
So great input, and I really appreciate that. Let me, if I may, just sort of pursue the notion of some of these hybrid instruments just a little further. Are there circumstances in which you see hybrid instruments more commonly used than not, or again, is it just a purely case-by-case sort of situation?
You know, I mean, the easiest answer is case-by-case, but I'll tell you, I tend to see hybrid agreements or hybrid documents and hybrid investments, as I said, a combination of debt and equity, at least as we draft it. In those situations where the funding source has some sensitivities, it can be a sensitivity related to control or negative covenants to prevent certain actions. It can be situations in which a company is starting out and they don't really have their 3 years of earnings and positive EBITDA. They can't really get a certain type of bank debt, the traditional loans, or they're wary of getting the higher interest, higher cost debt of sometimes a factoring or other hard asset lending approach. And it tends to be more born in the early stage, closely held opportunities. People are trying to kind of figure out a balance. So it tends to be there, but again, it could be, it runs the gamut. But those are more of the situations where we tend to see hybrid documents.
You know, one of the interesting things that your comments bring out is the very, you know, the very fact-specific and particular features of a lot of these instruments. And one of the interesting things about reading through these decisions and just sort of talking about them is how, you know, the analysis itself, certainly at the bankruptcy court and district court levels, and even to some degree, if you look at the cases carefully, even at the circuit court levels, it really gets into the very specific facts of an instrument or a particular transaction. Based on what you see commonly in your practice and also based on some of the decisions that we've taken a look at here today, are there any particular sort of facts that in your view might be a little bit more of a red flag than others for someone who was counseling a client in a distressed scenario, was concerned primarily, well, concerned certainly with many things, but concerned certainly with recharacterization? Are there certain features that you might counsel a client to try to stay away from based on what you've seen and what you've read, or no?
Yeah, there are. And I like to use the analogy of a golfer hitting a drive.
Mm-hmm.
You want to stay in the fairway. You don't want to be too difficult. And again, it comes down to the facts and circumstances. But generally speaking, you don't want to be too difficult and have so many bells and whistles, so many controls that you're on the board and they can't do this and they can't do that. Because even if you succeed in overcoming recharacterization, you now have stepped into the giant potential hole of equitable subordination, which, you know, again, the good news is it's still debt. The bad news is your debt just sunk below a lot of other debt, and your chance of repayment in the event that the company suffers problems is significantly impaired.
Right.
So on one hand, you really want to try and balance the issues. You're entitled as a debtor to ask for protections. Courts understand that. In fact, the court in State Street Bank, in exactly the point you mentioned, the court said in looking at when to establish these tests, that when existing lenders make loans to distressed companies, they're trying to protect their existing loans, and traditional factors that lenders consider, capitalization, solvency, do not apply as they would lending to a financially healthy company. So, you know, you want to recognize that you don't want to stay on the left side of the bunkers that you put so many difficult provisions in that you've risked both recharacterization because it's left typical what a normal lender would do. You also don't want to go into the right side bunkers, which suggests that you've been too lenient and too helpful. Yes, I'll defer interest. Yes, I will simply waive the maturity or extend the maturity. While these things do happen, the more that happens, the more it looks like you're an equity player. So to address that in terms of your question, I think that so often you have to have a balanced approach. And one thing that I would suggest is there's so many different ways to think about structuring. I think the case that talked about participation agreements, you know, creative attorneys should be thinking about, instead of investing or putting money into the company directly, perhaps joining up with an established secured lender to help the company in that context. You have much greater protections according to the case law you've discussed. I also think that one of the things to think about, again, is to perhaps bifurcate your financial support. Put some of it in a traditional loan and put some of it as equity. And yes, you can have certain bells and whistles, and yes, you can have on both sides, but it's a balance. So to kind of address your question and kind of in the totality, it's like golfing. Stay out of the left bunkers, stay out of the right bunkers, and just try and, you know, nice and easy, balance it and let it ride.
That's a great response. If I may, let me shift gears really quickly to Victor. I want to talk about some of the litigation aspects that these cases raise. You know, Victor, one of the things that I thought was interesting as a guy who does this sort of litigation myself was that the reasoning of Lothian Oil sort of change the basis on which recharacterization claims are founded, at least here in the Ninth Circuit. Rather than relying on Section 105, as a number of earlier circuits have done, the Fifth Circuit relied on Section 502, the claims allowance provisions of the Bankruptcy Code. Here's a question for you. Do you think the Ninth Circuit might have ruled differently in Fitness Holdings if it had been asked to support a recharacterization claim on the basis of Section 105?
Michael, I think it might have, simply because in Section 105 situations, the Ninth Circuit has been really narrow in interpreting that section to be sure that it is applying provisions of the Bankruptcy Code, and that what the court, or what a court in the Ninth Circuit is doing in a Section 105 situation, is something that is consistent with the Bankruptcy Code. And unless there is a basis in the code or in a statute in the code, in a provision of the code, to do what is being asked under 105, it's difficult to get that section to apply in bankruptcy cases in our circuit.
Yeah,
I don't know that the same result would have obtained. I think the Section 502 claim disallowance is a much more rational way to look at it. Is a way that is consistent with historical decisions under the Bankruptcy Code. The Butner case in the Supreme Court from many, many years ago, talking about claims, talking about state law and applying state law. And I think it's a much better way to go about it. And in addition, and what Lothian and Fitness Holdings do that is perhaps as significant as making it a claims disallowance process, is saying that recharacterization is not necessarily limited to insiders.
right.
That non-statutory insider, non-insider parties, other parties who simply have a claim, because anyone's claim obviously is subject to review and disallowance under Section 502. It expands the universe of potential parties who can be subject to these causes of action.
You know, one of the things that strikes me in looking at all these decisions, and I tried to capture it here on the slide we've got in front of us, is, you know, on the one hand, there are a multitude of tests, a number of different factors. Several of them seem to coalesce around a group of maybe 8 or 9 factors. And just to sort of take a 30,000-foot view at this body of case law, Victor, I was just wondering, you know, based on the recharacterization decisions that you've read, is it your sense that courts using one or more of these multi-factor tests tend to place a greater weight on some factors rather than the others?
You know, the starting point and the problem are the terms. When you use them, you're using them in the abstract, and you don't have the facts in front of you to say this is what courts will do in 7 out of 10 cases, or something that can be predictable. But obviously, the starting point is intent, and the factors, I think, are things that courts need to look at in order to construe the ultimate question, which is, what was the party's intent with respect to the transaction? In the State Street Bank case, Judge Carey focused on what the parties say in their contracts, what they do through their actions, and the economic reality of the surrounding circumstances. And I really think that those 3 things, when you think about it, really cover both what those particular factors provide for in terms of the factual analysis, and really relate to all the other factors as well that are found in the Lothian oil case and in the hedge fund investments case, the 11 and 13 factor tests that are in those cases. So I think those three probably do as good a job as any of covering the landscape of what you want to look at. And one thing that the three of us talked about before the program today was the idea in the State Street Bank case, and I know Jeff liked this in particular as a transactional lawyer, of construing intent at the inception of the transaction and where the parties stood at that particular point in time. And that's what Judge Carey focused on, but I don't know that courts necessarily have to focus on that. As things move forward and circumstances change, I think it's important, notwithstanding what Judge Carey said in the Third Circuit, that in other circuits where the starting point hasn't been so clearly defined in terms of doing the analysis, you not only want to be careful, as Jeff so clearly laid it out a few minutes ago, about what you do at the start, but as you go forward and as circumstances change, because they only wind up with us and with the people on this phone call, when things go badly, and they go badly because economic circumstances change, and where parties stand in the waterfall at the start may be very, very different as things go forward. And how you act at those different points in time may be something that a court at a later point in time looks at in deciding whether or not your debt should be recharacterized as equity, or whether or not you should be subject to claims of equitable subordination.
Those are all great comments. I'm looking at our time here. We have about 8 or 9 minutes to race through about 4 or 5 more slides. So let me, if I may, just sort of move ahead to our next slide. We've discussed what recharacterization is, so let's discuss very briefly what recharacterization is not. And this is admittedly not really the focus of our presentation this morning, but for purposes of completeness, I think it's important to raise it. Many of the decisions we discussed involved requests not only for recharacterization, but also for equitable subordination. Even though they're based often on the very same facts. Recharacterization, as we pointed out earlier, and as I'll emphasize again here, recharacterization is a judicial doctrine, while equitable subordination is specifically authorized by statute, in this case Section 510C of the Bankruptcy Code. Now, the statute itself doesn't set forth any specific criteria, so courts have generally filled in the blanks as to what is required. We don't really have the time to get into an extensive discussion of those factors, but the majority of cases require that 3 criteria need to be satisfied before a claim will be equitably subordinated. And I'll just go through them very quickly. First, the claimant must have engaged in some type of inequitable conduct. It could be fraud, illegality, some type of breach of fiduciary duties. There should be a showing of undercapitalization. That's something typically arrived at through a valuation analysis of the company. And capitalization is deemed not to be adequate if it wouldn't support a business of the size and nature of the bankrupt, and if at the time the advances were made, the bankrupt debtor could not have borrowed a similar amount of money from an informed outside source. So you've got some illegality, breach of fiduciary duties combined with undercapitalization, and finally some type of control over the debtor, whether that's a overwhelming ownership position, some sort of interference with the debtor's operations, appointment or control over the debtor or management, or so on. Those sorts of factors give rise to the inequitable conduct. The second prong of the equitable subordination analysis involves whether that misconduct resulted in injury to the creditors or conferred an unfair advantage on the claim, which is the subject of an equitable subordination attack. And then finally, the third prong, equitable subordination would not be consistent with the provisions of the Bankruptcy Code. Some courts have seen that as sort of a meaningless prong because equitable subordination is specifically authorized by statute, but other courts, so for example the State Street or the Scott Cable Communication case that we just discussed, look to whether or not the equitable subordination result would leave the Bankruptcy Code's priority scheme disturbed or interrupted. Let me go on just to one more slide here for purposes of completeness. We should mention that there are two other types of subordination that arise under Section 510. Mandatory subordination under Section 510B, which involves claims arising out of the purchase or sale of securities. Security is a term, a broadly defined term under the Bankruptcy Code, and the Ninth Circuit, as well as other circuits such as the Second and Third, have construed the phrase arising out of the purchase or sale of securities. They've construed that phrase very broadly. Contractual subordination simply preserves the enforceable rights that parties may have bargained for on bankruptcy law. So if you've got something, just to go back to our discussion about documentation, if you've got something in the documentation that entitles a party to subordinate other claimants, that typically will be the grounds upon which a contractual subordination claim is brought. And so, to close out our program with the wisdom of Warren Buffett, we've included some general transactional tips to help your client avoid swimming naked. But first, I wanted to toss out just a few more questions. And let me go this time to Victor. Victor, several courts have observed that recharacterization disputes and equitable subordination requests often grow out of the same general set of facts. We just mentioned that. In your practical experience, or based on the decisions that you've read, might there be any differences in litigating these claims, or is the difference really simply one of legal theory?
By definition, as you said, Michael, they grow out of the same facts. The difference is the standard and the burden of proof that you have as the plaintiff, as the trustee, or as the debtor in possession, in terms of demonstrating, based upon really the economics and the intention of the parties, whether recharacterization from debt to equity is appropriate when you apply applicable state law. Equitable subordination is, something that takes place based upon the actions or specific actions of the parties after the applicable debt instruments are created, and pertains to bad acts and inequitable conduct. So it's much more focused on conduct and what parties do, versus a more far-reaching analysis when you're talking about recharacterization and you're trying to figure out what their intention was, which may not be something that's as easy to figure out. I think equitable subordination is going to be much more obvious and apparent to you as a litigator than recharacterization at least might first appear to be.
One point that you raised earlier, which I thought was a really interesting takeaway, there are many interesting takeaways, I think, from this presentation, but one of them that I think is relevant here is, the circuit, and I guess by following the Fifth Circuit, the Ninth Circuit as well, has held that in certain respects, insider status doesn't really matter. Do you think that insider status might be, certainly that's the case for recharacterization, do you think that insider status might be more relevant in cases of equitable subordination than in cases of recharacterization?
It could be more relevant if you're talking about insiders who are also creditors
Mm-hmm.
and equitably subordinating their claims. It may not matter at all as it relates to lenders who overreach and take control and do some of the things that you outlined in your slides
Right.
A few moments ago.
Mm-hmm.
And those lenders are, of course, not going to be insiders, yet they can engage in the kind of conduct that could result in their claim or claims being equitably subordinated.
Yeah, it's a good point. The cases seem to be pretty clear with respect to equitable subordination that there is a lower standard that a party seeking equitable subordination will have to meet if you're seeking to deal with an insider than you would with a non-insider when you're talking about equitable subordination. I don't know that was clear or that distinction was terribly clear either in the Lothian oil case, and certainly wasn't addressed in the fitness holding case. But that was just one interesting point I thought was worth noting. Another thing that I thought was worth noting as well was the procedural posture in which these issues arise. A lot of times they're pled together, and so you'll see them typically in an adversary proceeding context. But where, at least in the Ninth Circuit and the Fifth Circuit, where it really is part of the claims allowance process, I think it's at least theoretically possible, and certainly I think procedurally defensible, to see recharacterization come up not just as an adversary proceeding, but also as part of the claims allowance objection process, and for that matter, even in a typical contested matter under Section 9014, where you're dealing with objections to confirmation or other sorts of contested matters. We've talked several points about how these cases are so fact-specific. What type of evidence, Victor, have you seen as particularly persuasive in terms of litigating cases of this sort? Or does it just really depend?
Litigating cases of recharacterization?
Recharacterization and or equitable subordination. Yeah.
I mean, I think in my mind, recharacterization is really going to be focused. For me, the starting point is where did the creditor stand in terms of its position from a valuation standpoint with respect to the assets of its borrowers under a liquidation or even a fair market value sale.
Mm-hmm.
How did that change over time? Was it getting paid? Were they getting paid? What kinds of add-ons did they have to their claim? Did that make it look more like equity than debt?
Mm-hmm.
Were there bonuses or extra kickers involved?
Right.
I think those kinds of things, in particular, not getting paid and not doing much about it, to me raises red flags that definitely warrant further inquiry.
Thank you very much, Victor, for that input. Jeff, we're essentially out of time here, but I'm going to toss one more question out to Jeff. Jeff, how would you counsel the corporate board of a struggling company considering approval of the company's entry into a loan with terms that differ significantly from a conventional debt instrument?
That's an excellent question, and one of the things that in counseling the board is to certainly remind the parties that certainly a company that's struggling, that's in zone of insolvency, it is a fiduciary duty to the creditors, and fortunately they're able to rely on attorneys and advisors that are appropriate in terms of the good faith business judgment.
Mm-hmm.
But again, one of the things to do is to really try and be creative and try and address both the economic issues and sometimes the parties and personalities. Often, and what's unfortunate about the situation, I know we have very limited time,
right,
is one of the best things to do sometimes is bring in financial advisors that are really creative and expert in dealing with troubled companies.
Mm-hmm.
There are a myriad as you saw with just some of the cases, there are no shortage of variations, all of which have, can potentially help or hurt your client. So in terms of advising the board, one of the things that we try and do is to sit down and, before we talk about the legal, let's talk about the economics. Talk about the business situation, talk about where we are in terms of capitalization, and then try and build a legal approach and documents that best address both the concerns and the economic reality, but also address the concerns regarding recharacterization and certainly equitable subordination. And sometimes that involves bringing in outside parties, get opinions. It's difficult sometimes in a troubled company environment, but it's certainly something you should think about.
That's a great point. I have to ask the one last question, and this needs, I guess, to be a very short question. But we were talking a little bit before the presentation about the impact of choice of law provisions in an agreement. Going back to your counseling to a client, how might you counsel a financially distressed client regarding an instrument's choice of law provisions?
Again, it's choice of law provisions is very interesting because on one hand, given what you're seeing with these different circuits and how their holdings, you don't want to find, if I may, you don't want to find you're using a map of Manhattan, Kansas to cross around Manhattan, New York.
Right.
You got to know what the standards are. You got to know what the rules are. There is some benefit, I believe. However, it's one of many things. In California, for instance, choice of law provisions, to the extent they violate public policy, they may be struck down. Certainly, if you raise the choice of law, if you have a Nevada and a California, or California and Arizona, California borrower and Arizona lender, and you decide to use Nevada law because you want to get around the anti-deficiency protections in California, you may raise a real red flag that someone will challenge. And one of the other problems is everything in what I do is negotiating. And when you put something on the table as a negotiating point, you raise the opportunity for someone to use it as a chip to try and get something else. I would just say, and again, I know we're out of time, but just to counsel that one of the things that we can do as attorneys in terms of drafting documents is, take the opportunity that State Street Bank, the judge, suggested, and that is make the document look like a debt document. And part of that, which many people kind of get away from, is use those recitals to tell the story. Tell the story from your perspective, what you want to try and achieve. Again, if you take a white horse and you paint it black, it's not a zebra. It's still a white horse. But having said that, the idea that you have the opportunity with the pen, whether it be a choice of law or other provisions, create documents that are most beneficial to your clients.
I think that's all we've got time for. Guys, thanks so much for a terrific presentation. Really appreciated the input and the insight. I guess I'm supposed to pull up the last slide here, and let me do that. Thank you so much for joining us, and we'll see you next time.
We did all the slides.